Hello and welcome to the Presumption podcast. I'm Sara Azari, one of your co-hosts, and with me is Jim Griffin.
Hey, Sara.
Hey, and Matt, our wonderful producer, Matt Fondelier. I finally got his last name correctly.
You did it. Woo!
I did it. And we have a very special guest with us today, a dear friend and colleague who I know from the National Association of Criminal Defense Lawyers, Jerome Buting, who goes by Jerry. Jerry, welcome.
Thank you. Good to have you.
Thanks. So Jerry is a partner in the Brookfield, Wisconsin law firm of Buting, Williams, and Stilling. He received his law degree from the University of North Carolina, Chapel Hill. He's a past board director of the National Association of Criminal Defense Lawyers and the recipient of the 2017 NACDL Champion of Justice Legal Award, and also the past president of the Wisconsin Association of Criminal Defense Lawyers. He was a trial public defender for 9 years in Milwaukee. Presently in private practice, his entire practice is dedicated to criminal defense, where he does both trials and appeals. He's defended the accused in many serious high-profile trial cases, including the Steven Avery case, which is going to be a big focus of ours today, as shown in the Netflix documentary, Making a Murderer. He lectures worldwide and is frequently sought after for his knowledge of the criminal justice system, the use of expert witnesses, DNA, and other forensic evidence. His first book is Illusion of Justice, Inside Making a Murderer in America's Broken System, which was published in 2017. I guess better late than never. You know, Jim and I read this book, and I, as you know, Jerry, I posted on social media encouraging everybody to read this book. I don't know why I hadn't read it before. It's phenomenal, and you just impart so much wisdom in it. A lot of it has to do with the Avery case, but you mentioned other cases as well. And so I just kept telling Jim when I was reading this book that there's so many parallels that I was seeing between the Avery case and the Murdaugh case, which is Jim's case with Dick Harpootlian, from your relationship with Dean Strang, very similar to Jim and Dick's relationship, and also just how dynamic your collaboration was in this case. Like you say, I do that too with other trial lawyers. The collaboration is a force multiplier. Just very much, I just kept telling Jim, you got to read this because if for nothing else, there's so many similarities. So I want to start with, obviously.
I did, by the way. It was a great book, Jerry. Great book.
I was going to say, it probably would cause you PTSD flashbacks.
Yeah, no, there were a lot of things in there that rang true for sure in my experiences. But I downloaded it on Kindle and I read it on my iPhone, and it was a great, great read.
So, look, we're the Presumption podcast. We started this podcast. It's now become a brand because there was such a big hole in media. You know, from our perspective, everything was sort of leaning towards guilt. And there's an entire chapter in your book, Jerry, on the presumption of innocence. And, you know, my favorite quote in this book is from Dean, that all due respect, counsel, the state is supposed to start every criminal case swimming upstream. And the strong current against which the state is supposed to be swimming is the presumption of innocence. But that doesn't always happen. Tell us more about what Dean meant by this.
Well, believe it or not, that was completely unplanned. That just sort of, the comment just flowed from Dean, as so many eloquent things do. It was at the beginning of the trial when the state, for, I don't know, at that point, 10 months, had charged Steven Avery with sexual assault and false imprisonment based solely on his nephew, Brendan Dassey's confession, which was, we believe, totally bogus. And they, without actually the state calling Brendan Dassey, they had no evidence to be able to prove it. And so we moved to dismiss those counts before the trial began, and the state agreed. And then Dean asked for a curative instruction, in essence, that would explain to the jury that they had that he had originally, the information originally included additional counts, but the state dismissed them. And that's when Kratz goes, well, if the state's going to have to start off this case swimming upstream, then maybe we won't dismiss it. And then Dean stood up and gave that eloquent quote.
Yeah.
So
he pulled from Kratz is the prosecutor, was the prosecutor. So he
yes.
pulled from Kratz's statement and tied in the presumption of innocence is what
Correct.
I
Yes.
So Jim, you had some.
Just jump in right there, Jerry. There is another chapter in your book titled "Presumed Guilty," and I guess we'll get to that momentarily. But it's not always the state comes to court and the defendant is presumed innocent, right? I mean, it's as you write in your book, the state really has the benefit of a presumption of guilt, and it's really hard to get the juries to engage in the burden that they're required to.
That's particularly true in high profile cases that get pretrial publicity.
Right.
But I think all defense attorneys know that even if the jury comes in and it's a case that nobody's heard about, they start off with the thought that, well, what's this guy doing sitting here? If the case got this far, if he's being charged, he's going to trial, he must have done something wrong, right? That's, I think, unfortunately too common viewpoint that jurors start off the case with. And, at least in cases where they're not so polluted by pretrial publicity, I think you can overcome that as a defense attorney and with help from the judge, explaining to them that, whatever they think, coming in, that he is presumed innocent and that, the state's burden is completely different at this point. But it is very, very difficult in this day and age with pretrial publicity. And then you add an additional layer of social media where people get a lot of information. Some younger people get all their information from the social media, it seems. So it is very difficult.
Yeah. And social media doesn't have, when mainstream media, at least there's some sort of,
standards,
ground rules and standards. And in social media, these are just sleuths and regular people, and they start creating and adding and inserting and misrepresenting. And it's incredibly dangerous because it just has, such just vast breadth,
Just because it's retweeted doesn't make it true,
Exactly.
Right. So Jerry, let's talk about, one of your big high profile cases, Steven Avery case. And, it was a subject of the Netflix documentary, Making of a Murderer. And I was one of the millions who binge watched it during COVID. And so I think a lot of people did because it did play on Netflix. But, there may be some people out there who have not heard about Steven Avery case, but just, tell us a little bit about it and how you got involved and how you and Dean ended up working together in that case.
Sure. So Steven was wrongly convicted, spent 18 years in prison for a sexual assault. He later was exonerated and had the luck that the crime scene evidence, or some of the crime scene evidence that linked to the perpetrator, not only excluded him by DNA, but also was a hit with somebody who another local law enforcement agency had believed was the suspect all along. So Steven gets out after 18 years. And as it starts to come out that there's information that the state knew about in that case all along, they knew about this other suspect. They did not tell the defense. And it looked like there was some deliberate manipulation of the evidence and hiding of the evidence. He filed a $36 million lawsuit against Manitowoc County and the Manitowoc County sheriff and district attorney who prosecuted his case. 2 years later, he is surprisingly arrested and charged with the murder of a 25-year-old photographer woman who took pictures for Auto Trader magazine, one of these little things you'd see in the news in the grocery store where people could take pictures of their car and advertise it. And it caused a huge uproar all over the country and in the innocence community, the innocence network community organizations. Innocence organizations were afraid that people were going to say, "Oh, look what happens if we let people out, even if they're wrongly convicted. Look what's going to happen. They're going to go off and murder people." And so It drew the attention of the New York Times. It was on the front page of the New York Times, and it therefore drew the attention of these two film students from New York to come out and look at it and see, this might be kind of an interesting sociological study. We'll talk probably a little bit more about that later, but Dean and I were not originally retained until about 5 months after he was charged. His lawsuit for $36 million settled for $400,000, a pittance for 18 years. Right. But he used that money to pay his civil lawyers for the civil rights case, the expenses that they had incurred, and then used the rest of it to hire private criminal defense attorneys, myself and Dean Strang. And we were both recommended by various sources. And so ultimately, that's how the two of us then took over and represented him from March of 2006 until the trial was done about a year later.
Well, there's another parallel right there between Avery and Murdaugh. That in your book you say when you do the math, you were getting paid like $9 an hour because you didn't get paid enough. After paying the expenses on the civil lawsuit and then, paying you guys. But, like Jim and I have talked about this with other guests, we have to see through matters. And even if the client runs out of money, or the money's not enough. And so it's something that we're all familiar with. In this book and the overall Avery story, you really sort of portray the flaws and the failures of the criminal justice system. And it ranges from everything from junk science, like the hair analysis used in Avery's prosecution, to DNA that, debunked that junk science that the prosecution had previously relied on. And then there's like defense counsel misconduct, false confessions, and then just to like straight up lack of physical evidence. So tell us about what some of these travesties and flaws were in your case and how the system failed with respect to them.
Well, the one thing you didn't mention is Brady evidence, and which for listeners is the United States Supreme Court ruled that the government, the prosecution, must turn over any information they have through them, either in the prosecutor's office or through the law enforcement agencies, that material evidence that's potentially exculpatory evidence pointing to a defendant's innocence, or even mitigates the offense. Mm-hmm. And the problem with that is in a criminal case that you don't know what you don't know. And time and time again, we find years or even decades later, as happened in Steven Avery's first wrongful conviction, that the prosecution withheld evidence from the defense. And his current, Steven Avery's current attorney is dealing with that very issue now. You mean on appeal? On appeal. On appeal. There's information that Dean and I were not provided that might very well have made a difference in the prosecution and defense of the case. Pretrial publicity, we talked about a little bit. That's a problem.
In your book, you describe a press conference that was held by, I guess, the prosecutor and the sheriff after there was this coerced so-called confession from the nephew, Brandon. And, my experience, I thought that's a no-no that you don't go on national TV or local TV and talk about someone's confession. And that just poisoned the well right there for you, I'm sure. You mean
you're talking about by the nephew's own lawyer?
No, the prosecutor.
They had daily pressers, right?
That didn't come. That didn't happen until the trial. Jim, I think, Jim, you're referring to the press conference when Brendan Dassey was actually first charged in March of 2006.
Yeah,
and you're right. I mean, there are ABA standards, ethical rules that specifically for prosecutors that tell them they are not supposed to discuss in detail publicly outside of a court setting a suspect's confession. Here, they not only discussed it, but the prosecutor, Ken Kratz, gave this unbelievably Dean and I often have said that, frankly, that was his best closing argument in the entire prosecution, except that it wasn't based on facts. It was completely made up. There was no evidence to support it, and in fact, that confession never even came in to Steven Avery's trial because they were not able to get Brendan Dassey to flip and become a state's witness because he immediately recanted what they claim he said. But yeah, so the prosecutor calls this press conference and begins it by telling people that if there's anyone under the age of 15 in the room, they should probably leave. And what does that do? That just makes you turn the volume up. Ooh, this is going to be good, right?
Right. I'm leaning in.
Yeah, exactly. And then he tells this powerful, emotional story that was a graphic rape, torture, murder, stabbings, slitting her throat, shooting, all of these things while she's begging for her life. I mean, just horrid description of what supposedly happened. And when I heard that, I thought, they made it sound like he had been the nephew, the 16-year-old developmentally disabled, or at least limited nephew, had been harboring this guilt of what he and his uncle had done for months, and finally just came out with this narrative, oh, this is what happened. Well, when you actually looked at the confession, it was completely different. It was all of the story came from the police, not from him. His answers were, monosyllabic. Yeah.
Right.
No.
I remember that scene.
I don't know. And they strung it together in a story that was so powerful that one of the television reporters, who later went to law school, later told me that he was so grossed out by hearing it that he went outside the courthouse where the press conference was and sat in the TV truck for a while and called his parents to just try and, talk through this horribly inhumane thing that he had heard happen.
And you mentioned in the book that one reporter, asked, well, does the forensic evidence back this up? And Katz made a dodge and, just avoided answering the question, right?
That's right. One reporter was, smart enough to say, well, now, is there any DNA evidence that backs this kid's story up? And suddenly Kratz became coy and didn't want to we're not going to talk about that right now. Well, we want my story out. Well, then later when we got the discovery in the case, which was about 2 months later, we discovered that at that very moment, the day they did that press conference and told that whole story, they already knew from the crime lab analysis of the supposed crime scene, Steven Avery's residence, that there was nothing to back it up. There was no DNA, not a single cell of DNA of hers was ever found inside that trailer, which would have been a bloody scene. I mean, and they examined it carefully. They ripped the carpet off the floor. They peeled the paneling off the wall, and they looked for any evidence and found nothing. And they knew all that when they told the public this ridiculous and horrific story.
And at the time, Steven was in custody. He was in jail. He was already charged, and the public is hearing this so-called confession from the prosecutor, which ABA rules prohibit. And then fast forward, you're in a hearing, and Jerry, you and I share this experience, and I think any criminal defense lawyer out there who's had a high-profile case can relate. You go out and talk to reporters about what you just said in the courtroom, and then you get a nasty letter from the judge saying, "Oh, be careful, Mr. Buting. You're violating the rules on pretrial publicity." I mean, it's just not fair and balanced out there for us. I'm telling you, as you know. But
right.
Well, Jim got in trouble because he tweeted literally a Washington Post article. He didn't even say anything about it. He just retweeted someone else's article.
Not my cross-examination. Yeah, and I get.
And then he got the spanking. So I want to talk to you about the media in your case. It played a huge role, right? You're, aside from the staircase documentary, it seemed like, this was a very unique circumstance where your trial prep was followed. It's very different than, having cameras in the courtroom for the trial. This is like pulling the curtain back so that people could see what goes on before. So it was a big deal. It was unprecedented. Did that ultimately help, hurt, and why?
Well, it ultimately had no effect whatsoever on the trial. I had never participated in anything like that before, and we thought long and hard about it. We thought, you're right, other than the staircase, which almost nobody had seen back then because it was on, mail order DVDs was about the only way you could really see it. There had not been a perspective of what it's like for the defense counsel to prepare for a very serious crime like this, or defense of a accusation like this at trial. And so we thought it would be educational if anybody ever saw the documentary. We, of course, never expected it to have this kind of exposure globally. It was not a Netflix project at the time. It was 2 film students, graduate students from New York University. But it's, we only had 2 conditions, one of which is kind of laughable now that I think about it. But one of them was that they not record, they would not be privy to any direct attorney-client discussions that we had with our client, Steven. But the other was that they not air anything, not even a trailer, before Steven's trial was done and Brendan's trial was done, which I had no idea how long it takes to, in post-production, to put something like this together, much less sell it. And at that time, there was not even a streaming market. So that never happened. Nobody ever saw any of that behind the scenes stuff. But Kratz, the prosecution, knew it was going on. And in fact, although after Making a Murderer came out, he claimed that the producers had not given the state the same opportunity pre-trial to work with them. And there's a letter in the file that specifically says, yes, we want you to do this. They were offered the opportunity and didn't. Instead, about 2 months before trial, the prosecutor subpoenaed the filmmakers with all of their footage. And they had to go out. And again, they had no financial backing, really. They were just students. They had to go out and hire a media lawyer to defend their First Amendment rights. And ultimately, the subpoena was quashed. But I suppose that was the closest you could come to, a potential way in which our participation might have backfired if the prosecution had got a hold of that before trial.
Yeah,
right. But there were also daily pressers, which were really unusual. Can you tell us about how that started? I think the prosecutor started it, and if that was a tool that you could use to kind of change the narrative in any way.
Sure. So, I had never done anything like that while a trial is going on either, but the prosecutor announced to us and the judge in chambers, like the Friday before the trial, that the media had contacted him and wanted to do daily press conferences with him. And that he had decided, I'm going to only do every other day. And the Teresa Halbach's brother would do the alternate days. And we said, well, wait a minute. He had already he'd been interviewed a lot by the media before trial and was clearly just an agent of the prosecution. And so ultimately we came up with a compromise where all of us would do press conferences at the end of each day, but that no questions would be asked about what was coming up, and that we could talk about what had happened during court that day on the theory that this jury wasn't sequestered, as most are not these days, and they're told not to watch the TV and search on the internet. But if they had violated that, they at least would only hear what happened, but mostly what they already heard in court that day. And so we had these press conferences every single day. And as the trial began, the media knew nothing about the only narrative they had heard was this horrific press conference that the prosecution gave at the beginning of our representation. And after that, we were essentially under a sort of a pseudo gag order. And so we could not present the defense side, the fact that there was no corroborating evidence, for instance. And so they didn't really know much until the trial started. And then through cross-examination, all of a sudden, in the first day, they came up to me after and said, wow, we thought this was a slam dunk case. There's some really interesting issues. And so the media during those press conferences, I think, became, they asked a lot of good questions, frankly. And they learned a whole different side. And what I was able to do sometimes, and I've done this part in other cases where I've had high profile media coverage, is during a break in the action, I may be cross-examining an expert, let's say. I would go and talk to the reporters and say, and sort of use them as a sounding board. Did you get where I was going? Did you understand this point? Because if they didn't, then the jury probably didn't either. Sure. Most of the reporters were more educated, frankly, certainly in this case. And so then we would go back into court. I would sort of, now let me go back for a minute and follow up. And so we use them as almost a mock jury in real time. And so there's a little bit of that with the press conference as well, that we could fine tune the next day if it looked like from their questions they weren't really getting the points we were trying to make.
It was a good gauge. Like now we go on Twitter to see what people are thinking or saying, and but to have that directly from the reporters is great. I think Jim wants to get into DNA because we have a lot of our viewers, are fascinated by DNA and now genetic genealogy. So turn it over to Jim.
Yeah, just switching gears a little bit. I know that DNA exonerated Steven Avery after 18 years, and you write in your book how DNA has really debunked a lot of the forensic evidence that was used to convict a lot of people. And when I say bite marks, hair analysis, shoe print analysis, and of all the most unreliable is eyewitness testimony. And right. Can you address that for us, please, Jerry?
Sure. So. Eyewitness testimony is a little bit different than some of the other junk science, I'll call it, types of evidence. But, we knew even before DNA, psychologists had already been studying the fallibility of human memory and human identity, ability to make identifications, particularly cross-racial. The myths that I'll never forget that face, and, when the gun is pointed at me and, all these details are somehow burned into your memory. Psychologists had already proven long before DNA in study after study after study that those were myths. And often it was just the opposite.
And in Steven's case, the first conviction was an assault case, right? And the victim
correct.
had identified him.
That's
wrongfully, right? That's
right. And to her credit, she felt horrible when she discovered that he was exonerated, and that she was very certain in trial that he was the guy, and she identified him. It turns out that the identification process they used with her was sort of deliberately skewed to try and get her to pick Steven because of malice that the department had against him. But once DNA happened, and this is an important thing that viewers and listeners need to know, almost all of the so-called forensic sciences did not come from another an application in the world. They were created by the law enforcement and by prosecution. They're really the FBI crime lab was the brainchild of J. Edgar Hoover back in the 30s, and they were designed to try and give a more objective basis for jurors to decide cases that used to be he said, she said, or eyewitness identification. They would then bring in these experts of the so-called, lab coat effect, that the jurors would then be told, aha, this gun matches, or there's this blood spatter, or this hair is similar. And bite marks and all of this stuff. It was those disciplines, those scientific disciplines were never used in any other real world practice. Unlike DNA, which came from medicine and biology and basic research. And so when DNA burst onto the scene, it ultimately proved that case after case where people had been certain from eyewitness identification or from bogus FBI created types of science like microscopic hair comparison or bite marks, that in fact, those people were innocent, that DNA proved they were innocent, not just a reasonable doubt. And so really in the 90s is when that started to change. And then the Innocence Project in New York started. And, unfortunately, there's a lot of cases where DNA cannot answer it because either prosecution or I should say law enforcement didn't collect the evidence, right, or the case is so old it's been destroyed.
And you talk about another case that was impactful to you. It's the Ralph Armstrong case that you finally, after 20 years, of trying to get him exonerated, 29 years. Yeah. So I know that was rewarding, but it's also frustrating to know that he had to spend 29 years in prison before, the truth came out, right?
Yeah. And 15 of those years, I was working on the case. So,
wow.
People get frustrated when they see how long this post-conviction process is for Brendan Dassey or Steven Avery. And, again, that is part of one of the flaws of our system is that it is so difficult to undo a wrongful conviction in America that the belief that a judgment should be final, this doctrine of finality, as lawyers would call it, is worshipped so much that it trumps the evidence that points to a wrongful conviction, and it makes it very, very hard to reverse convictions.
Right.
Is Armstrong the case that Scheck
yes
pointed you to? Okay.
Yeah. So that was a case that's so old that the television series MASH featured as part of the timeline of when witnesses were watching MASH and what time it was. But it wasn't in syndication. This was in its first run.
Wow.
Right.
I mean, it was a 1980 case. It's that old.
MASH makes me feel old.
Yeah.
And in that case, there really wasn't any forensic evidence. There wasn't much at all tying Armstrong to the offense, and there was
the interesting thing,
but that was about it, right?
It was a very, very thin circumstantial kind of case, and it was a landmark case because the police had used hypnosis on the only witness who saw a suspect going into the victim's apartment building.
Oh my God.
And they used all these unbelievably suggestive procedures, including having pictures of my client's car in the room while this guy is going through hypnosis, and he looked at them. They took a break and left him alone with them.
Oh my God.
They did record it on a video. I mean, it's a ancient VHS tape, and that case ultimately went to the Wisconsin Supreme Court on direct appeal, and the Supreme Court said, well, henceforth and forevermore, no hypnotized witnesses are going to be allowed unless these specific procedures were followed. But in Ralph Armstrong's case, it didn't matter. No harm, no foul. So it didn't help him, even though it became a landmark case.
What was the purpose of the hypnosis? I'm sorry to get hung up on that, but this is fascinating to me as somebody who doesn't follow this stuff.
This witness who was really kind of a bit of a flaky guy himself was sitting on the porch next door and told the police, gave a description, which, as it turns out, was off by 6 or 8 inches from what Ralph Armstrong's actual height was. And he couldn't actually give much more detail than that. And so they said, well, let's let's hypnotize you and see if you have a memory you just don't remember. And in the memory, you could, or in the tape, it's unbelievable. You can actually hear when he gives the height. I think it was medium height. What do you mean by medium? About like me. Well, how tall are you? I'm 5'6". And you can actually hear the detective, who, by the way, should not be in the room, lean over to the hypnotist and say, "The suspect's taller. The suspect's taller." You can actually audibly hear that whispering. And then he starts, leading the witness, the hypnotist starts leading, could he be taller? And,
oh my God.
So that was the purpose of
gotcha.
hypnosis.
So on that note, there was, sort of law enforcement stuff, but there was also defense attorney misconduct in this case, with respect to Brandon.
Yes.
Brandon, yeah. I remember when I was watching this guy in the documentary, I was I was so angry. I just wanted to like punch the TV screen and punch him, Tell us what he did, and ultimately, were there any consequences?
So this is an attorney by the name of Lynn Kaczynski. He's named, and you see him in the documentary. And he was appointed by the public defender's office to represent this 16-year-old boy. And before he had ever, some of this didn't come out until later, on Brendan's own appeal in federal court, when they produced his time records, because it was a public defender appointment. He had to keep his time. And it turns out in the first month of his representation, he spoke to the media 32 times and visited with his 16-year-old client who's charged with murder once. And before he had even met with his client or talked with him at all, and on the phone or otherwise, he gave an interview, television interview, in which he says, obviously what this young man did is morally reprehensible. And, he basically confessed his guilt without ever having talked to his client. Then, about a month or two later, the police wanted to interview Brendan again, because they knew that some of the story he was telling them that they were feeding to him and he adopted didn't fit. And so they wanted to talk to him further, and they really wanted to get him to flip as a state's witness. And so this defense attorney essentially colluded with the prosecution. There is an email between him and, I believe it's one of the law enforcement, if not prosecutor, saying, well, let's wait until after the judge rules on my motion to suppress his confession. And at that point, he'll be weakened, because we're going to lose. And that's in fact what happened. They had the hearing, challenging the confession as being involuntary, and the judge denied the motion to suppress. And then at that point, this defense attorney sent in this investigator to go talk to him, to ostensibly to do a polygraph with his client in the jail. And you see this, it's actually video recorded and in the documentary. And when I first saw this, in fact, I thought, wait a minute. I've never seen this before. First time I saw that video with this guy, O'Kelly, was when Making a Murderer came out. And then I realized, the prosecution didn't have to turn this over. They didn't even have it, ostensibly. It was created by the defense. And this guy, who is supposedly working for the defense attorney on behalf of Brendan, coerces him into trying to get him to confess as bad or worse, frankly, than the cops themselves. He has Brendan write out this statement, and then he looks at it and he reads it and he says, well, is Teresa in there? Because, his statement is he knows nothing about this, really.
Right.
And he's like, no, well, then I can't help you. Do you want to spend the rest of your life in prison? You can't do it. And he's, on and on like this with this 16-year-old kid. So after he gets him to change his story, and that's when you see this little stick drawing where, the woman is supposedly, spread eagle on the bed. This investigator then calls the detectives and says, it went very well. You should talk to him now. And they set up this appointment the very next day. And on the very next day, it just so happened that the defense attorney had training for the Army Reserve. I think he was a captain, and he had his annual training. And so he said, "Oh, go ahead, interview my client without me being there."
Wow.
Did this guy get disbarred? Please tell me yes.
I'll try and get to the end of this quickly. So what happened, he goes in, they do this other interview. And in this interview, they're really challenging Brendan because it's like, this doesn't fit. You're lying to us. Now they're sort of admitting it. And shortly after that, Brendan tried to fire his defense attorney, and the judge refused. Said, "Well, are you fighting with him?" "No." "Well, what's the problem?" "Well, he thinks I'm guilty." "Oh, that's not good enough. Well, I'm not going to give you a new lawyer for that reason." But then the public defender, the state public defender, found out that this guy that they appointed allowed his own client to be interviewed by the police, a 16-year-old boy charged with murder and rape, and they suspended him, his certification to handle homicide cases. And that really forced the judge then to remove him, because if it went to trial and he's convicted with a guy who's not even certified to handle homicides anymore, that would be reversible error. But Kaczynski fought the public defender, and he did it like an administrative appeal of his suspension, and ultimately I think he was suspended for 6 months and then reinstated to handle homicide cases. But by then he'd been removed from Brendan's case and moved on to other clients.
Oh my God. And he was literally working with the prosecutors. It's crazy to me.
And then a postscript, he's later becomes a judge in Wisconsin.
No.
I gotta say, watching Sarah's reactions to your stories I feel like I'm watching Sarah watching a horror movie right now. You're just like, what? Oh,
horrifying.
Yeah,
I remember when I watched the documentary, I was like, wait a second. I had to put it on pause and go, who is he working for? Like I literally was confused and thought maybe he's part of the prosecution's team, because this can't be. And I was like, holy shit, this guy actually is the defense lawyer. So it was.
And his defense, by the way, his argument is, well, he was trying to cut a deal for his client. He was trying to get him to cooperate, to get a deal for him. But, when you got a client who's maintaining that he's innocent, and that this is a false confession, and that he recants from the very beginning, and you don't even do the investigation and allow him to be interrogated again by the police, that's a pretty egregious.
And that poor kid was, he was, I don't know, delayed or challenged, or where he wasn't even, he could barely articulate, it was so hard to watch. Anyway, Jim has an important Murdaugh related event.
Jerry, when I was reading your book, you described the situation that I think the defendant's last name is Oswald.
Oh yeah.
You were handling the appeal, and you're reading the transcript of the jury selection, and some juror comes up to be voir dire, to ask questions, and have you heard about the case? And the juror says, no, I really hadn't heard about the case till I got here, and we're all back in the room and everyone's talking about the case, and they're not supposed to be talking about the case. And so the lawyer then asked the judge to re-question the jurors who'd been qualified to see what they've learned during the jury selection process. And the judge refused it, wouldn't allow it. And then the defendant gets convicted, and then you get on board and you do what we recently did in the Murdaugh case, go out and start interviewing participants in that jury selection process. And it turns out that one of the jurors, one of the citizens who came for jury duty, who did not get selected, told you that, we talked about it. And one of the guys who ended up on the jury says, I believe he's guilty, and hid that opinion. And you tried to get a new trial on that in the Wisconsin state courts, appellate courts, and you were denied. But ultimately you were able to succeed. And if you'll walk, our viewers and listeners through that whole process, and because, we're about to start down that journey in the Murdaugh case. And, so if you just give us a roadmap, if you don't mind.
Sure. So that was, again, a very high profile case, unusual in the fact that it was a bank robbery, and then a police captain was tragically shot and killed in the escape. This was a father-son, very, very strange dad that had really sort of brainwashed his 18-year-old son for his entire life. And so anyway, as they're fleeing this robbery and murder of a police officer, some enterprising reporter and photojournalist was listening on a scanner and heard that they were setting up a roadblock to try and catch these guys. And then he got there and was able to film as these two suspects hit this roadblock, and there's a shootout like Bonnie and Clyde, videotaped. And then it is just like this exclusive, gold mine for the media, for local media. So they play it over and over and over in the nightly news. Every single time that the case was reported on at all, they would show this clip. And so during the jury selection, which again, I took over on appeal, this one juror claimed, they'd gone through 4 days of jury selection. They'd only gotten to around 50 jurors. They still had another 100. And on the last day, suddenly they, for the first time, found somebody who had not seen the video on television. And that's what you're referring to. And he says, right. No, I really don't follow the news. I don't watch television. And frankly, I've learned more about this case in the last 4 days down in the jury room than I ever knew before I got here. Right. And then the judge refused to investigate further. And ultimately when we took over on appeal, we found a juror who was not selected, but who was down there. And we brought her into court, and she was able to testify because it wasn't about jury deliberations. This was before the jury was sworn. This was in the assembly room. Mm-hmm. And she came back to watch the trial, as sometimes does happen, we know, with jurors who aren't selected. And she saw this guy sitting on the jury who ultimately was one of the ones that was not struck as an alternate. So he rendered a verdict of guilt. And she's like, oh my God, that's the guy who was mouthing off downstairs about how guilty this guy is. This trial is a sham and a waste of time. And so we presented her in post-conviction hearings. The judge said, doesn't matter, not giving you a new trial. The Wisconsin appellate courts agreed. And the federal court, the district court, disagreed and said that this was outrageous. And the judge had an obligation, a constitutional obligation, to investigate further when evidence of wrongdoing, juror bias, is presented to you. And he was a guy he's still a judge in senior status, Judge Edelman, who all the talk radio, the conservative talk radio, then said, oh, he was a Clinton appointee. He's a liberal. It's going to get reversed when it gets to the Seventh Circuit based in Chicago. And in fact, it was not reversed. It was unanimously affirmed by Judge Richard Posner, who was a Reagan appointee, a very conservative and esteemed jurist, who was equally outraged and said that, no matter how, what's the point of going through a trial in the first place if the jury is going to be biased and believe in the person's guilt beforehand? So it was reversed, and you may be facing the same thing in the murder.
Yeah, and just so that people who don't know, I mean, you can exhaust your appellate rights in state court, but you still have an avenue to go to federal court to address pretty serious constitutional deprivations, and so it does have to rise to a pretty high level, and that window of review in federal court keeps getting narrower and narrower as Congress keeps passing more restrictions on how you can get into federal court. But But, in our case, in like your case, the South Carolina Supreme Court doesn't get the last word. It's usually the federal court, right?
Mm-hmm. I have a hypothetical for you, Jerry.
Okay.
Let's just say that judge that it goes before is a material witness to the misconduct by the jury. Should that judge be disqualified?
Well, it's actually more common than you might think. But it's still a relatively unsettled area of the law. And we had a case in Wisconsin where one of the issues was, did the judge participate in the plea bargaining, which you're not supposed to do in Wisconsin. Judges cannot tell, and it was alleged that the defense attorney said, hey, if you plead guilty to this, that was a high profile case too. Here's the piece of paper. The judge wrote the number of years he intended to give you. We met in chambers with the prosecution, and here's what he said. And then, of course, he got like double that on sentencing. And so he challenged it. And that judge did have to step down and actually did testify in a post-conviction hearing. Denied, of course, that he did any such thing. And but it was one of the rare cases that I've seen where the defense was allowed to actually present testimony from a sitting judge.
Well, look, I mean, let me be honest, because I was just setting up a very vague hypothetical, but Jim filed a very robust petition today in the South Carolina Supreme Court. Obviously, I know this episode's dropping, weeks later, but essentially, in his case, there was the clerk of the court that communicated with the jury in a very unprecedented way about very material things, such as the defense's case before the defense puts on its case, and also the defendant's testimony before he takes the stand. So jurors have sworn affidavits, like there's two of them, about what this clerk did. The problem is that with respect to some of those communications, the judge was very well aware of it, not happy with the clerk when he found out that she'd communicated with the jurors directly. And so he's definitely a material witness in any sort of, in the hearing that will come up on the motion for a new trial. And so now if you added, this is another hypothetical for you, Jerry, if you add to that the idea that this judge was also personally biased, wouldn't that make it a stronger case for him to be disqualified?
You want me to handicap that particular motion?
I'm not going to.
I won't do that. But I will say this: I mean, you see it even now at the level of the United States Supreme Court when it comes to the whole what standards are there for giving justices free vacations with litigants or people who are at least interested in some of the cases that come before them. And there's a lot of unsettled law. I don't know specifically in South Carolina what the rule is going to be on recusal, but it's becoming more and more of an issue on many cases, partly because of all the money that goes into the election campaigns for judges and justices. So whether this, all too often, the courts have said, we're going to leave it up to the individual judge to decide whether he or she must recuse themselves. And, the one case, a Caperton case from West Virginia, where I think a coal miner was involved in litigation and had given a whole lot of money to one of the candidates who then was a judge in the case. Ultimately, the U.S. Supreme Court put some limits on that, but all too often it's going to come down to the own judge's decision. And, the judges don't want to admit they're biased.
Yeah, of course.
They don't want to step down from a case in which that's alleged, because it's almost like they think it's an admission of wrongdoing when it's oftentimes not. Sometimes it's just a human failing.
Well, my favorite thing it was like this little PS at the very end of Jim's motion today when I read it was like, We don't want any disciplinary action against this judge. We actually respect this judge. We think he's great, and he's very honorable and distinguished. But we just want our clients' rights to be protected, or he was violated. So but of course, no judge wants to be disqualified, because it's a violation of the code of judicial conduct, and it's not a good look. But there's a lot of layers in Jim's case. Not every case is the same. Every case is different. And I just brought that up for fun because I like the motion. But let's end with bail in jail. That's also been a topic that we've been, really interested in with our guests. And the right to trial is probably the most sacrosanct right. And yet so many Americans plead for reasons that are just not really valid. And you argue in your book that, when you can't make bail, it puts this pressure inevitably on the defendant to wrap up his case right away, plead out. And a lot of it often comes from the lawyer. And so how do we fix this really broken aspect of our system?
Well, it's controversial. Some states, Illinois most notably now, is banning the use of cash bail per se, in order to try and, because here's the problem. And this became a problem in the Avery case, where they recorded every single conversation that he had with anybody in his family on the phone or in any visits. And then they wanted to use some of he didn't really say anything incriminating, but they were threatening to use some of the statements that he'd made in these recordings. And we argued that was essentially a denial of equal protection, because the rich man who can bail out can sit at home and talk to his family and friends, and even besides his own lawyer, and not have it recorded and used against him. But the poor person who can't afford to post bail cannot. And I mean, that's just one of the inherent things that's most unfair about using cash bail to keep people in jail. And there's states now that are reducing or eliminating cash bail, and they're finding out that the frequency with which people come back to court, which was supposed to be the whole reason for cash bail, is just the same, whether they have cash bail on them or not. And so it's not necessary to put cash bail on somebody in order to ensure their appearance in court. But it's controversial because, especially here in Wisconsin, sometimes judges make mistakes. Yeah. We cannot predict future behavior of anyone. And sometimes in hindsight, it looks like someone's bail was maybe a little too low. And we had a horrible case of a Christmas parade where a gentleman later convicted of this offense drives his vehicle through a Christmas parade, kills all of these people, hit these grannies that are dancing in a troupe and a Christmas parade. And then they find out that he was released on a relatively low bail, and essentially by mistake, because the prosecutor did not know, about another pending matter or something like that. And so, there's a huge uproar about how, we need to increase bail, not reduce it, which of course still doesn't account for something like this. The offense that he was bailed out on was not a homicide or a sexual assault or something like that, where he couldn't have posted it anyway. Right. But it is really unfair, and there are people who sit and wait for months, and now, particularly after the pandemic, for years before trial, and they are presumed innocent, and yet they're sitting in custody. And then the prosecutor comes to them, maybe the case is weak, and they say, let's make a deal. If you plead guilty so that I can save face, basically, I'll reduce this charge and you can get out with time served. And I talk about a case in my book that I took over for the Innocence Project, got this a homicide conviction reversed, where the guy, I think he had been sentenced to parole eligibility in 55 years, some really long sentence like that, which you see a lot of here in Wisconsin, quite frankly. And it was reversed. And then I took over the case for trial. And as we prepared for trial and started the prosecutor started realizing that it was weak, on the Friday before the trial started, he offered to reduce this charge. The guy had been sitting in prison for 5.5 years by then, or on pretrial bail. And he offered to reduce it to a negligent homicide offense that had a maximum of 5 years. So as long as he pled guilty to something,
he got time served. Yeah,
he'd get time served and walk out. And what would you do? I would take it. He put his faith in the system once and got 55 years. He, I think, had a better lawyer the second time around, but still, he took it. And so you see this time and time again throughout the system.
And you know what? Add to it, I have a client right now who's he's mentally ill. He's got terrible addiction issues. Add to it those kinds of layers, and a very sweet deal is made. You got to communicate it to the client. You disagree with it. You think it's a triable case, telling them to go forward. And they're like, no, I need to get out. I want to get out right now. I don't care. They're not giving me any more time. I'm going to get out. And it's like one of the hardest conversations, to have. And you know that this client's going to end up right back where they are really quickly because they're not getting treatment. They're not, doing the right thing or should, taking your advice, but it's ultimately their right. Right. So it's, it gets,
and they're the ones that go back to jail or prison, not you.
Exactly.
So you have to put that decision in their hands ultimately.
So we want to close with, we, our audience and our listeners are very much fascinated by DNA. And I know that's one of your fortes. So I hope that you come back and join us when the Koberger case out of Idaho starts, moving closer to trial. We loved having you on today, Jerry. I know you had some difficulties and you made it happen, and I really appreciate that. And if we don't chat before Thanksgiving, have a wonderful Thanksgiving.
Thank you. Thank you for inviting me, and I'd be happy to talk again. DNA, we could talk all day about.
Yeah. Thank you so much, Jerry.
You're very welcome.
Thanks,
and if this
Jerry.
is your first time checking out the show, please subscribe. We're on all the podcast platforms. The show's also on YouTube. You can follow us at The Presumption on all the social media handles. And until next time, Sara, Jim,
we rest.